It is July 2nd of 2026, and this is the Court Gallery. Coming up, what happens when a defendant is found with machetes, a wig, and an entire arsenal in his truck? Well, they end up in court, of course. In this compilation featuring Judges Simpson, McNally, and Thornton, we'll see that, plus a young woman with over 23 probation violations whose mother tries to intervene on her behalf. But you have to stick around for the final case. It's one of the most explosive courtroom meltdowns I've seen all year. A defendant's simple plea goes off the rails, turns into a bond hearing, and a tirade of profanity erupts, followed by multiple contempt charges. All that and more starts right now.
Court does call the case of the people of the state of Michigan versus Kevin Chichabani Lowry.
Good morning, Your Honor. Sam Bernstein with and on behalf of Kevin Lowry. That would not be Lowry.
Who's not? Who's Lowry? Who is? Okay, well, who is he? Rowry? That's my. Rowry. Okay. Are you ready? I'm ready. Then give me the file. And then
Give me this one.
all right. I'll pass that previous matter. Court will call the case people versus Lauren Rowley.
Rich Hand to be at Lauren Rowley, Your Honor. Please state the record.
Lauren Jamar Rowley. Thank you. All right. What are we doing?
Honor, in front of you, you got a request for adjournment. I would like, if I can get Lauren qualified for felony treatment court. It's probably going to require, case is going to have to be screened, assessed, interviewed, and obviously, given the nature of the charges, have to be some begging and pleading involved. So if we could have an adjournment for a month, I think that would give me enough time to see what we can do.
Any objection from the people?
Not the request for adjournment, Your Honor. I'm not sure if we qualified or not. Based on the charges.
Right. Okay, I can do the 30th of this month, or I can do the 6th of August.
30th would be fine.
Probable cause conference will be adjourned July 30th, 2026, 9 a.m.
I do have a second request.
That's why we weren't going to call Shan's case.
The entire offense involved massive amounts of alcohol and drugs, and I know he benefit from inpatient residential treatment, and I asked the court whether they would be willing to consider a release to inpatient residential treatment if we can find him a bed.
Your Honor, I am opposed to any change in bond at this time, including a release to residential treatment. In this case, police were sort of just driving around and checking and noticed a red truck parked parallel near the Carpenter Road Target at about 6 o'clock in the morning, parked between the concrete barriers and the actual buildings. So closer to the building and the vehicles are supposed to be able to get. Pittsfield officers made contact with the defendant, who was laying parallel to the truck on the concrete ground between the truck and the buildings. They made contact with him and they noticed that he had 2 machetes in his belt, was wearing a Halloween mask, happened on June 22nd, and had a wig nearby as well. After they looked at his face, they noticed his face was covered in some sort of blue paint or blue makeup. They made contact with him. He was obviously intoxicated. They looked through the window of the truck and they saw weapons. They got a search warrant for the truck. And in the truck, they found an AR-15, full magazine, safety set to fire, 3 additional magazines for the AR-15, 1 with PAR, 1 in the backpack, and 1 in the drug case in the back seat. They found a shotgun with an attached knife or a bayonet loaded with 5 needles, an additional black face covering, an iPhone. There's a search warrant pending on the phone, a holster in a black backpack in the front seat of the car, a handgun in the center console, and a Milwaukee knife located on the driver's seat, as well as a trauma pack medical kit. So the people are extremely concerned about what may have been the plan or what this might do if released. Frankly, I think what I just said is more than fair, and I ask the court continue at this time in the interest of public safety. I do acknowledge the defendant has no prior criminal history whatsoever.
Your Honor, I said up front the charges are serious, and I understand, but my client, obviously, the level of intoxication from both alcohol and drugs is really severe, and I think treatment would be the best option. And I understand the court's reticent at this point in time, but we're going to do what we can.
Oh, you don't even.
I know.
Innocent, but go ahead.
All right, we're going to do what we can to help him. I think Lauren's looking for treatment, looking for help, looking to be able to find a way to become comfortable. So
I've got to make sure nobody's killed in the interim. So motion for bond reduction is denied and any modification is denied.
All right. Thank you, Your Honor.
Court does call the case of this Phoenix Thorns.
Your Honor, Raymond Cook.
Your Honor, on behalf of the Phoenix Thorns on the one of the matters, Judge. I'll find out which one.
Good morning, Your Honor.
I think
Jackson for Phoenix Thorns on the matter ending in 5052.
0709 for the PD, Judge.
Okay, all right. Side process of elimination, right?
Yeah, that's right.
Thanks, Lawrence. Thank you. What are we doing? Don't everybody jump in at once.
That's right. On the PD case, the 0709 case, Judge, we'd like to set it for a preliminary examination.
Discovery is complete on that one.
To our knowledge, Judge, yeah.
All right. And on yours, Ms. Saxon?
Your Honor, I'm going to ask for an adjournment on this bond violation because of some information I just got last night that I did discuss with the prosecutor, and I'm trying to get an assessment done.
Okay, so if I adjourn yours out, is 2 weeks going to be enough for you to accomplish what you need to accomplish, or you need more time?
I need more time, Your Honor, and if you prefer, I can try track with with the other case.
Well, the other case, they're requesting an exam. But what I'll do on your case is I'll adjourn yours out to July 30th.
Okay.
2026, 9 a.m. All right.
Thank you.
And on the 0709 matter, would people have their witnesses available to 14?
We'll do our best, Your Honor.
All right. And in that matter, preliminary examination will be set for July 14, 2026, 9 a.m. before Judge Washington.
Kind of, Mr. Horns would like for us to address bond in this matter. I know that the P.
Go ahead. He's got a violation in the other case, girl.
Correct.
So
Your Honor,
probably want to make it quick. No, I'll let you talk.
I'll try my best, Judge. Phoenix reports that he is, not allegations in my case specifically. I know that the bond in my case is lower than the violation matter, but I guess this argument could work for both cases, Judge.
Okay.
He's asking that the court consider releasing back on the tether. There's some that Ms. gather from the title of the individual who's worked with him in the past. I think that the information does explain a lot about the decisions that have taken place that has brought him to where he is now. I'm sure he's going to want to get a type of written report to present to court on on his behalf. He does have family support. He lives with his mother and his younger siblings. He states that he, based on his interactions with this court, has already enrolled or at least started the enrollment process for school and is slated to start Washtenaw County in the fall. He was working this semester or this summer. He had a lot of plans he had set for this summer, wanted to spend time with his family and his younger brother specifically. Today is his birthday. Today is also the anniversary death of his aunt, who was very, very close to him. He's been doing a lot of work on himself. He reports to me that he's currently in counseling and just been working through a lot of issues or, problems that he has been facing. He is desperately asking if the court consider at least letting him go back home, putting him on home confinement at the house so that he can at least be around his family during this time frame. I do believe that there's an assessment that Ms. Saxon is going to have completed. We have toyed with the idea of something, a little bit more serious, but we'll need to work through those issues.
I don't need a response from the people, given the violation and the way on the assessment. I'm not going to change his bond until I see something else that would lead the court in a different direction. So motion for bond reduction instead.
Thank you, Judge.
Court calls the case of the People versus Aronde Anderson.
And then on behalf
Defendants, on behalf of Mr. Stevenson, who was approaching. Aronde, when you get to the podium, state your name for the record.
Rondé Anderson.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment in this matter. We were prepared to set it, but the people have informed us that they
discovery coming former field conference.
I'll adjourn it out then to July 16, 2026. Man,
That Mr. Peterson had paid college visit from jail. His client revision before arraignment from his parents. And then after he was arraigned, he made 2 more calls to her from another thing. I have concerns given that in the most recent lengthier call that was about 7 minutes, he says to her, my friend doesn't come. If my friend doesn't come, I'm going to get a motion dismissed because the victim ain't coming. But I don't know if they're going to do it or not that day, but hopefully they do dismiss it. And I have concerns in saying these kind of things to the victim in this case. I also have concerns with the facts of this case that could potentially be to, in addition of an A1 charge at exam, given the nature of the strangulation and the threats that he was saying to the victim while he was strangled. So at this point, I'm going to be asking that his bond be raised to our original request of $100,000 cash surety rather than the $50,000 cash surety, given that he violated the bond from the jail.
Your Honor,
I already revoked his phone privileges.
So you are loose.
Pardon?
You're
All right.
Your Honor, in regards to the phone calls, I'm awaiting the calls from the people. Ms. Enna states that she'll get those over to us. I did speak with my client prior to knowing about these calls. He absolutely knows now, especially after my conversation with him, that
He didn't understand the magistrate.
well, I can't
Magistrate
necessarily.
Rotella speaks in very clear English.
I know.
But go ahead. I'll let you go with your argument.
So, Judge, we're asking that he still be allowed to, I don't know if there's a way that they can block the complaining witness's telephone number. He reports to me that he does have other numbers. He has a child, how old is he? A 1-year-old child who, at the time that he was arrested on this matter, was in the hospital in critical care. He has desperately trying to find out any updates on the child. It's not the child that he has in common with the complainant in this matter. It's just another child of his. So he needs to be able to at least communicate with his family members to check up on the status of his child. Initially, we were going to address bond today. Obviously, I know the court is not gonna approve any reductions to his bond amount due to these new calls that the people have presented. I have spoken with the people in regards to a potential for an agreement to a release treatment. Have expressed that they are not in agreement to that whatsoever. We would still present that to the court. Something that we've discussed, and my client does admit that he is coming to the realization that there may be some substance abuse issues that he needs to address very quickly. So we wanted to see if the court would at least consider allowing him to be released to an inpatient treatment facility on a tether. I've explained to him exactly what that looks like. He is prepared to do that if allowed. We'd ask that the phone privileges not be revoked so that he can communicate with his family. I don't know how we can isolate that of the complaining witnesses communication or phone.
Why would I do that if he has already abused the process? I mean, I hear you, but I don't even understand any logic in me doing that.
Only because of his ill child, Judge. That's the only thing that would differentiate this from any other case where somebody has abused the phone process.
People's motion to raise the bond is granted. I'm going to raise this bond to $150,000 cash as surety. The defendant's phone privileges as well as texting privileges are hereby ordered revoked. Thank you.
Thank you, Judge. Anything on the release to treatment?
I will not order release to treatment.
Okay.
I don't know that he would cooperate in that process. And if he got out, we back because he comply with anything else. Some simple things. Thank you.
Thank you, Judge. Okay.
Court does call the case. People versus Michael Brown.
As it always.
Oh, really? Does he want it revoked? You know what? Tell you what, go talk to your client. Tell him my offer to him is to have his bond revoked if he wants to keep talking. I'll bring him back out and let him know. I'll wait for your reply. You really ought to be ashamed. No, you really should be, Smith. Court calls the case, people versus Rodney Napier.
Public Defender Don Liba for Mr. Napier.
Your name, sir?
Rodney Napier.
Thank you. Court has before it a plea form that indicates that the defendant would be pleading to an edit count 2 of larceny 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Correct. That is correct.
May I have him sworn?
Right here. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole, truth, nothing but the truth?
I do.
State your name, please.
Rodney Napier.
Sir, it is his court's understanding that you're going to be pleading guilty to the charge of larceny 200 to 1,000.
Yes, sir.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yeah.
You understand that the fine could be increased at 3 times the value of the property take. That's greater than $2,000. That would become the maximum fine.
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one signed on your behalf?
Yes, I did.
Any questions regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
Sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
All right. On June 24th, 2025, at the location of 318 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan, What'd you do that makes you think that you're guilty?
I used the credit card that I found on the bus.
Okay,
So,
and you
I-
didn't have the owner's permission to have that?
no, sir.
All right. Did you use the card?
Yes, I did.
All right. And what'd you use it for?
Alcohol and cigarettes.
Okay. Did you? Is this really truly going to be larceny on value or no?
No, Your Honor.
Oh.
Yes.
Yes. All right. And so you didn't have the owner's permission to use that card?
No, sir.
All right. And you knew that you didn't have permission to use that card?
Right. Yes.
And in using that card, you were attempting to try to defraud the people that you bought or the business that you bought the alcohol and cigarettes from
Yes, sir.
out of there. All right. Sir, I do have to advise you, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea. The court would no longer be bound by any sentence evaluation or recommendation. Do you understand that, Judge? Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
At 9 a.m.
July 21st, 2020, 9 a.m. before Judge Garwood.
Thank you, Your Honor. I did want to address bond, please.
Go ahead.
Thank you, Your Honor. Your Honor, Mr. Napier has now taken responsibility for this offense with his plea. He has informed that he does have stable housing in Ypsilanti that he could stay with his wife. We have no objection to a tether to ensure appearance. He has told me that he has a phone in his property. At the time that he initially failed to appear, he explained to me that he had suffered 2 serious losses in his family, including his mother and sister both passing away, and has been struggling with mental health as a result. He does intend to contact CMH immediately upon release.
Is there any response from the people?
I believe that this was set at 10,000 due to offense one where failure to appear. I have no objection to this with it.
How'd you come back into custody?
The officer stopped us.
Stopped us?
But I was in the car.
He was a passenger in a traffic stop, Your Honor.
So you didn't turn yourself in?
No, sir.
Were you just gonna stay on the run?
At the time, I'm going through mental problem. I'm post-traumatic distress and all that. I have death in my family on. And at the time, I didn't care too much.
It can only get worse.
Yes, sir.
He's being very honest, Your Honor.
No, I know he's being honest, but I'm trying to let him out. So if people keep talking, that doesn't happen. I'll reinstate the defendant's previous bond of $5,000 personal recognizance. He also needs to report over to the Department of Community Corrections or prior to his release for a GPS location track together.
Thank you, Your Honor.
Right.
Yes, thank you.
You're welcome, sir. You have a good 4th of July. Court. Stay ready. Oh, court calls the case of People versus Lee Pat.
Then we have Ronan.
Sir. Michael Gaddy, Assistant Public Defender for Mr. Patton, Your Honor.
Your name, sir.
Andre Patton.
What are we doing?
What did you state your name? Okay, Your Honor, I have
Hours ago.
discussed this matter with the prosecutor and with Mr. Patton. We'd like to set this matter for a preliminary.
This is next one.
Your Honor, the people have offered not to habitualize this matter. What's commonly referred to as the super habitual. If you were to waive, see.
Discovery is complete.
To the best of my knowledge, Judge.
We'll have their witnesses available the 14th. Preliminary examination will be set July 14th, 2026 at
9 a.m. with-
that just messed you up, didn't it? At 9 a.m. before Judge
Just Garwood.
Garwood.
Good.
Just seeing
Moment, can I speak?
attention. Sir?
At this moment, I would like to get something on the record. I would like to remove Mr. Gaddy as my legal representation.
Okay, why?
Information I could have used earlier. Yeah, it's.
Why do you want to do that?
I don't feel he has my best interest at heart.
Seriously? You're saying Mr. Gotti has a client that he doesn't have their best interest at heart?
Yo, Mr. Gaddy.
For that, Mr. Gotti, how long have you been practicing?
A little
Sorry.
bit, Judge.
A little bit, like 25 plus years?
Yes, Judge.
And you're gonna tell, and he's been practicing before me for that long, and I've never seen a point in time ever that he didn't have his client's best interest at heart until today.
Mr. Gaddy has been very argumentative with me in certain instances.
Maybe he's told you what you need to hear, but you're not listening?
No, he has done that.
Okay, that's his job.
I understand that, sir.
So are you gonna hire your own attorney?
No, sir.
Well, you got the PD's office, that's it.
Sir.
And the PD then has assigned Mr. Gaddy to represent the case. So if you want to do something different, I'm gonna undo this setting of preliminary examination. And I'll just adjourn it out for you to decide what you want to do.
I'd like to move forward to prelim.
You would like to move, and you understand that Mr. Gaddy will be your attorney maybe on that prelim.
Okay.
Well, okay, what?
Move forward. I have to move forward to preliminary hearing.
So you're withdrawing your request to have Mr.
I am,
Gaddy
sir.
move?
I am, sir.
Probably a smart move. Yes.
Apologize, Your Honor. I was going to say that the offer was not going to be kept open for exam. It was kept open until this hearing, and at this point, it will not be kept open for exam.
It will not be kept open so he can get the habitual.
25. Correct.
You understand that? And you still want to go forward with prelim?
Your Honor, I don't know if Mr. Patton.
He's not listening to his attorney. That's what the problem is.
Yeah, I don't know if Mr. Patton would consider, in the court would consider adjourning this 1 week and the prosecutor consider keeping that open so that he can, I have advised him of this. I've explained the statute.
The 25-year minimum, which probably caused a dispute, which why he wants you removed, because a new attorney is going to come in and tell him it's not that. You've got to be kidding me.
I don't know if Mr. Patton and Your Honor would consider it appropriate maybe to adjourn this 1 week so I can make sure that he is. I'm very sure he's fully aware. I just want to make sure that given the events of today that he is completely aware and there's absolutely no confusion or question about it. But that would be up to him, Ms. Zenda, and Your Honor.
I would have no objection.
What do you want to do?
I want a better understanding of what's going on.
So you want me to adjourn it so you can talk to Mr. Gaddy and listen to what he has to say? You may not like what comes out of his mouth, but you.
Not that, sir.
Pardon?
Not that. It's not that I don't like what's going on. It's not that I don't like what he's saying. That
What do you want me to do? You want to go ahead with your preliminary examination or you want an adjournment? Those are your choices.
I'm going to waive my prelim. I don't want to do that.
Nobody's asking you to waive your prelim. You want your prelim or you want an adjournment at which time if you decide after that adjournment that you want a prelim, it'll be set for a prelim. Those are your choices. Pick one.
Understanding, sir, what they were telling me was if I adjourn my preliminary, it will move the habitual. That's what was explained to me. Is that not correct?
No, Your Honor. I've explained that the people have offered, and again, I've explained that the people have offered not to habitualize this matter and such in the way stated with the mandatory 25 should there be a waiver, and that the people would withdraw that offer once an exam is set. I don't think we had adjourned this last week or last time for this eventuality, and we did discuss the matter. So, to the extent that there may be some confusion, I think perhaps adjourning this a week would.
Is that what you want to do, sir?
We can adjourn it, sir.
Where is it? Just mark it. You want 1 week or two, Mr. Gaddy, for him to understand what's going on?
Your Honor, I can. I believe 1 week will be ample.
During to July 9th, 2026, 9 AM. Bond continued.
Thank you, Your Honor.
Yeah, just so everyone's aware, Mrs. Enda will leave that offer open until next week.
Because she's a lot nicer than I would be.
Janaya Amani Arian Neely. File number 25W838, I'm sorry, 839-829A. Where's Ms. Neely? Vince, would you yell for a Janaya Neely to come in here, please? Yes. Thank you. Morning, Mr. Osmond.
Good morning, Your Honor.
You look awful serious this morning.
Well, I came here early because I have a big felony sentencing at,
What, did you already talk to the prosecutor?
yeah, I did. I talked to Mr. Bologna. We have it all worked out.
As soon as he brings it in, I'll take you. That's a civil infraction, I think, right?
Yes, sir. Thank you.
Have the file yet. As soon as I get it, I'll call it. Janaya Amani Arian Neely. This is file number 25W8389829A. And also, yeah, your name?
Janaya Janela.
All right, so. Oh, good. Okay. All right, ma'am. You have a show cause here. It is alleged that you failed to pay your fines and costs as ordered, balance owing $895. That is count one. Do you understand the charge, ma'am?
Yes.
Count two, that you failed to submit the weekly testing as ordered on June the 4th of 26. Do you understand the charge?
Yeah.
Count three, you failed to submit the weekly testing as ordered on July the 17th of 26. And count four, that you failed to submit the weekly testing as ordered on June 22 of 26. Do you understand those charges?
Yes.
Those are all technical violations. And then it's also alleged that you failed to pay for a scram tether. So you have 5 counts. Do you understand all those charges?
Yes.
You also have a non-technical violation, which is commission of a crime. They think that you were convicted of driving while license not valid. Through the 33rd District Court, through this court, offense date was May the 25th of this year. Do you understand that charge?
Yes.
So if you plead guilty, or if you're found guilty, given the number of violations that you've had, you could be incarcerated on this case for the maximum provided by law, which in this instance is up to 93 days with credit for any time that you've already served. Do you understand that?
Yes.
Did you sign, read, and understand this advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yeah.
All right, you have the right to a lawyer. I'm going to give you a lawyer. Fair enough?
Yes.
All right, so I'm going to enter a not guilty plea for purposes of arraignment. I'll give you a lawyer, and you will go meet with the lawyer, and then you will come back and find me, okay, with your lawyer. Any questions? Good luck. Thank you. You can go right out in the hallway. John, we need the probation lawyer on that one. Why don't you call in Jessica? People against Janaya Amani Area Neely. This is 25W839-829A. You're gonna need to bring your best game on this one.
James Schloss on behalf of this meeting.
Your name, ma'am?
Janaya Janela.
All right, so you understand how many violations she's had, right? In the past.
To Your Honor, and
And so I'm gonna, how was she going to proceed on these?
so she's going to recognize that she's in violation, Your Honor.
You're
She
gonna,
also was here with her mother today. She does have a cognitive mental disability and
well, maybe that's why I've been so incredibly kind, overly kind.
it
She's
could-
got 23 prior violations, shame on me. I think I gave her a few days once. So she's gonna either have to plead guilty to these, or we're gonna have a hearing. We've got 4 counts: failure to pay, failure to submit the weekly testing on 3 occasions, and then failure to pay for the scram tether, and then a non-technical violation of being convicted of the drive while license not valid.
I did review that with her, Your Honor, and yes, she will acknowledge that. But I must say to the court that knowing how the court feels about money, but also the opportunity to allow people to come to the court and address why they might not have it. I don't know if that sank in with her last time. She was trying to deal with her probation officer, and I don't know if the information got before the court. But I did reinforce with her, she has problems, make sure she calls in, just like you told several other people before. She is, you're working now, is that correct? She just got her job back. She's at a Hampton,
Okay, let me take the plea first though, okay? That's all right. Your name?
Just vote on, Your Honor.
Ma'am, if you plead guilty to these, I want you to understand your probation on this could be revoked. You could be incarcerated for 93 days. Do you understand that? And you signed an advice of rights form today. Is that true? You got to keep your voice up. If you plead guilty, you're going to be giving up all those rights and we're not going to have a hearing. Do you understand that? Nice and loud.
Yes.
Is the count one that you failed to pay your fines and costs as ordered? How do you plead? Is the count two that you failed to submit the weekly testing as ordered on June the 4th of 26? How do you plead? Is the count three that you failed to submit the testing as ordered on June the 17th? How do you plead? Got to keep your voice up. Is the count four that you failed to submit the testing as ordered on June the 22nd? How do you plead?
Guilty.
Did you fail to submit the testing on June 4, June 17, and June 22?
Yes.
Did you fail to pay your fines and costs as ordered?
Yes.
Is the count five that you failed to obtain a scram tether? How do you plead?
Judge, that's not the count. She failed to pay for the scram tether.
Well, yeah, I'm sorry. Failed to pay for the scram tether. I apologize. Failed to pay for the scram tether. How do you plead? Did you fail to pay for the scram tether?
Yes.
And is the count six, which is a non-technical, that you failed to refrain from violating a law, being convicted of drive while license not valid through this court, June 11 of 26, offense date May 25 of 26. How do you plead? All right. Were you convicted of that offense on that day? On June the 11th? Were you convicted of drive while license not valid on June the 11th? Was the offense date May the 25th?
Yes.
And again, you failed to submit to testing on all those dates, June 4th, 17th, and 22nd, correct?
Yes, sir.
And you failed to pay for your scram tether?
Yes.
And you failed to pay fines and costs, correct? So here, I'll accept your pleas. Here's the problem. You're still in operating while impaired. I'm going to let you can feel free to tell me tell them what you told me. Go ahead.
Yeah, so I'm concerned. She is complying with the scram tether in the sense of there's been no positive alerts, nothing like that. She hasn't paid on it. The last payment she did make was the other day on June 23rd for $50. Her current balance is at $979. They want to shut off the device at this point. They want it back. I'm concerned about this regarding that we went over her conditions. Janai is very concerned regarding money. I'm aware of the conditions and aware that she, had some money struggles. But like I explained to her as well, there's only so many extensions I can give. There's only so many extra time I can give. Eventually, we do have to come in front of you and discuss this. She was very upset about her violation. She called me about 6 times in a 10-minute time frame. She was very upset with the clerks the other day as well, asking if she was going to go to jail today or not. We cannot tell her what's going to happen today. We do not know. You make all the decisions, not us.
Why did I extend initially I told her to remain on a sober link until April the 5th.
She was not compliant on the SoberLink device at her last violation, so we removed the SoberLink device. She went to jail for 8 days and then wanted her on the scram.
How long has she been testing negative for everything?
Every she does show up for testing, she's negative. But the last test I have for her, she did show up for testing on June 26th. She was negative. Prior to that, the test I had was June 8th. She was negative.
Prior to that, the test I had was May 31st. When she does show for testing, she is negative.
And the scram has had no positive
The
results.
scratches had no positive alerts, nothing like that. It's just for not paying for it. And again, at this point, they're gonna shut off the device.
Where's the mother? Come on up here. Young lady, how are you? What's your name?
G.
I'm sorry,
G.
can you spell that for us?
Yes, DEQUANDRA, last name GE.
Thank you. Did you want to say something? Did you want to say anything?
Yeah, I was explaining to the lawyer that she has a disability where she does not understand. So like the money, she was thinking like if she's paying different courts that she's okay. So she's been trying to take her money and pay this court, pay that court, but not really trying to put the focus towards the on the screen. So she doesn't fully understand what's going on. Cause I explained to her, like, she was under the impression at first that she was coming to court to get her tether removed. That's what she said. She's my probation officer is trying to put it in for my tether removed, and I said, well, if you're being violated, that's not what that is. And I thought about it, like, she's not understanding she's not understanding what you guys explained to her. And she has had some struggles with working and not being able to pay it.
Where do you work at?
I work at an urgent care and
The Hampton,
yes, and Trenton.
Hampton Nursing.
How much do you get paid?
16.
How many hours do you work per week?
8. We just
So,
40.
okay.
8 a day.
Yeah, 8 a day.
All right, so you're making $640 a week gross, right? And then they take taxes out. Right?
Yes.
I would like to note too, she does have her warrants are still active. The one I did look up is she has one out of the 25th district court. That is for the other driving under the influence. That warrant is still active.
Why didn't you go surrender on that?
I thought I did when I went to Taylor. I even went to Wyandotte.
25th is Lincoln Park though.
I didn't go to that one yet.
Why not?
I was trying to make the money for it, sir.
The ones in the Wyandotte was a driving license suspended, and then the ones in Taylor were driving tickets.
I told you to clear all your warrants by March the 1st of 26 too. This is July. Why did you have to go take care of that, young lady? It's a drunk driving. It's not a simple case. I mean, she needs to grow up a little. I get it. I'm trying to be understanding now. But she needs to pay attention to what she's doing. And
I'd like to add too, house arrest did state that they've tried to contact her several times to make payment agreements with her. Every time they do talk to her, she'll promise payments and then she defaults on the arrangements that they agreed upon. So house arrest has talked to them, she has communicated with them and then doesn't agree to the terms.
when's the last time we had any indication she was consuming anything?
I mean, as of right now, again, she's not showing up for testing all the time, so I don't know if she's consuming. I don't think she's consuming alcohol because of the scram tether. I really don't believe she is. I don't know if she's consuming anything else, though any test she does appear for, she has been negative on all of them. It's just not getting her to appear to all of the weekly tests, because again, she missed, in the month of June, she missed 3 tests.
Just certain times I just gonna be having the money to pay for the lifting and to test for it sometimes. So sometimes I'll have to contact Terry, try to, reschedule for a different, day.
You're making my job difficult here. You know that? I mean, you're really hard. I don't know what to do with you. I can't have people violating left and right like this. I'm sympathetic to what you're going through, but you're just not complying with orders. I'm expecting you to go over to Lincoln Park today, right now. Today, right now. Do you know what I mean by that? I mean today, right now. It's 10 after 10. I'm gonna expect, did you drive her here?
Yes.
I'm gonna expect that you guys go over to Lincoln Park today and be there by 11 o'clock. It's only 22 minutes probably from here to Lincoln Park. Let's start with that. I'm not gonna require her to be on the scram anymore. I mean, I don't know if I've ever had anybody with this many violations. She's scheduled to come off when?
The scram, technically, you've never given her a date in the scram, so I did tell her I would discuss with you today taking the scram off, because you
We're
never
going to
gave her a
do
date.
that. And right now we have her on weekly testing.
She's been moved to bi-weekly testing as of a couple days ago, Your Honor.
Okay? What do you think?
I'm concerned. Again, I feel like we did not great in the beginning. After she went to jail in her last violation, we did really well when we got out of jail. She was communicating with me really well. She was showing up. She didn't have money for the scram right away like you ordered her to. Because she was communicating with me and told me what was going on, I gave her time to get the scram. She didn't end up getting the scram until like 2 weeks after she got out of jail. But I worked with her as long as she was appearing for urine testing. I told her I'd work with her on it. So again, it's feel like sometimes we do well for a little while and then she disappears and I don't hear from her for a while. And then she'll reach out to me and say, should I appear for testing today? And I'm like, well, you missed testing the last 2 weeks in a row. Yeah, you can appear today, but if you would have told me about it before, then maybe we could have worked out something a little sooner. So it wasn't 2 weeks later that we're appearing for a makeup. I don't know if she'll be able to comply with probation again with the money and all the monetary amounts. I just worry that this is a hole she's dug herself that we can't get out of now.
So how are we gonna solve that? How are we gonna solve that?
The only suggestion I can make, Your Honor, if I may, is that she's living with her mother. And if she could, and this is, I have nothing that the court order, but maybe turn over the checks to your mother. And perhaps she can start making sure that payments are paid. Is that something that can be done between the two of you?
Yes.
You got yes from both of them.
Did she do her treatment?
She's been enrolled in treatment. She does have a little bit of a lapse in treatment, but it's not on her. Her therapist became a supervisor, so they moved her to a new therapist now, and that new therapist hasn't reached out to her yet to schedule it sounds like. She did also complete her victims impact panel. She has not completed her work program days. We've tried to schedule her for a few of them. It never seems to work out.
You gotta get those scheduled. You gotta get going. Heather, give me a review hearing date in 5 weeks, will you please? First of all, take your time.
Okay, Judge. When did this, do you want it on a Woodhaven day or just for a
It
review
doesn't
hearing?
matter, whatever, probation day is good, especially if Mr. Schloff's here.
I'm here usually on Thursdays.
Then let's set it for a Thursday.
Well, our next Thursday, you are off in August on the 13th. So Mr. Schloff wouldn't be here again until the 27th of August.
How much can you afford to pay weekly?
Speak up. $50.
Did you hear what she said, Mom?
Yes.
We're gonna set your review hearing for August the 27th at 8:30. That's gonna be a jail start date. 30 days.
If she's not in compliance.
She's not in compliance. You're to pay house arrest $25 per week and the court $25 per week beginning July the 13th. I've written down you're to test bi-weekly instead of weekly. You appear for the review hearing on August the 27th. You are to surrender to the 25th District Court on the warrant today. Scram tether to be returned in the next 24 hours. Unless we can take it and give it to
I
them.
think full house arrest, Joel will usually come and meet them somewhere.
So that's to be done within the next 24 hours. So she's gonna make that call. I will consider suspending your jail term if you remain compliant. So that means you have to go to Lincoln Park today. It means you have to pay $25 per week to the court in the house arrest starting July 13th. It means you have to test every time you're supposed to test, and that's bi-weekly. It means you are to surrender to the 25th District Court on the warrant today. Not tomorrow, not next week, today. Do we understand one another?
Yes, sir.
You're gonna put that down as a jail start date on August the 27th. And again, the scram tether to be removed. I think I've covered everything, but I can't have you miss testing. You cannot miss testing. I'm taking the scram off. You cannot miss testing. If you miss testing, I'm gonna require you to serve the 30 days. Do we understand one another?
Yes, sir.
Mom, I think she needs some guidance here.
Yeah.
So I'm glad you came. She's giving the staff a hard time around here. That's not right.
No.
Gonna give somebody a hard time, you're gonna give me the hard time, okay? I don't like that. They don't deserve that. Okay? That's it. Do we understand everything, ma'am?
Yes, sir. Thank you.
Good luck. Go down the hall, get your jail start date. That's what I'm doing. Thank you.
Court work program.
Oh, yeah. But by the way, you're gonna schedule her on the court work program too. And you're to comply. Young lady, come on back up here. You are to go to the court work program. This was ordered in February. This is July. This is 5 months. We're gonna get you scheduled now. And it's devilishly hot out there, so I don't mind if you push it out a month. Start in August, but whatever. Good luck. We understand, right? Good. Come on up here, DeQuandra.
Me.
That's you?
Yeah.
E 223B1444404. Do I dare say like mother, like daughter? What are you doing?
Yeah,
Yeah, but you're not taking care of this. What's your name? Go ahead.
I got into a really bad car accident in February. It broke my arm in 2 different.
I told you to pay $25 per month beginning January the 10th of 26. That was back in this. Did I tell you to come and talk to me if you didn't have the money? Or did you come and talk to me when you didn't have the money?
No.
Why not? You weren't in the hospital. Your accident wasn't until February, right? I told you to start to pay $25 per month beginning January 10th. You didn't pay, and you didn't come talk to me on January 10th. Now, come on. You gotta be responsible here.
I agree.
Good. I mean, I don't think there's anything to quarrel about. When are you gonna pay this? I can't keep giving you time to pay when you don't follow the time to pay orders and don't come and give.
And I don't have.
Why aren't you working?
Because my doctors put me on restrictions from not lifting nothing more than 20 pounds, and the work I do, I would have to lift 20.
What kind of work do you do?
I was working in a warehouse, Amazon. So just because I'm still in physical therapy, I don't want me doing no heavy lifting.
Pay $25 per week. I'll start it beginning on August the 14th.
Not 25, leave about 50 a month. I just paid some money for that 60 a month. I think it would be.
Jeez, you guys drive a hard bargain with me. Per month beginning August the 14th, okay? Come on. Now, don't make me issue a warrant again. If you do, I'm not gonna be this nice. Okay? Come on. You gotta show a little bit of respect. Good luck. Jean Trozine.
25 a month.
Yes.
Beginning August 14th?
Correct. And the 14th of every month thereafter, correct.
When 25 again?
August 14th.
Okay, thank you.
Okay, good luck. You're too nice in this job. Jean Louise Trozine. Which one do you have, counsel?
Morning, Your Honor. There was another attorney in here on Trozine, but he was.
Oh, well.
Yeah, come on up here. Sophia Elizabeth Pancone, 263-306-865. How you doing, counsel?
I'm great, Your Honor. How about yourself?
Not too bad. Good to see you.
Good to see you, Your Honor. Todd Lantot, on behalf of Sophia Panconi, who stands to my left.
Your name, ma'am?
Sophia Panconi.
All right, so this is a disorderly places, and does she stand mute and waive formal reading?
Yeah.
People against Jean Louise Trozine, 05I-82886.
Thank you and good morning, Your Honor. Pleasure.
Pleasure to see you, Mr. Baldwin.
Thank you.
How are you?
Mike Baldwin, P 65417 on behalf
Of Jean Trozine.
Rosine.
Your name, ma'am?
Jeannie Louise Trozy.
Where in the world has she been?
Judge, back in 2005, she got mixed up with crack. It just destroyed her life, everything around her. She's been 7 years clean. She wanted to go ahead and take care of her.
Where does she live? She live on Farnham?
No, check the advice of rights form.
Okay.
That's her updated address and phone number. She took it upon herself to come into the court to clear the warrant, and she wants to deal with this driving while license suspended matter because she wants to get her license back. And again, she's been 7 years clean. That was a different chapter in her life. She was being irresponsible. I see she forfeited a $400 bond.
I know.
So, but
Really, ma'am, really? I mean, this is kind of laughable though. 21 years? Geez, I was a kid 21 years. Well, I don't even know if I was a kid then, but it's a lot closer to being a kid then than I am now.
I've spoken to her about the age of the case. It causes problems.
You have $200 with you, right, ma'am?
Yes, she does.
2,010%. I'm just gonna make it 200 cash.
I have some background information, but if you want me to waive that, I will know.
No, I don't need any. I don't need any. She waives reading and stands mute. True? Did I cover that?
Yes, for purposes of arraignment, I believe July 15th is her pre-trial date.
Is that the date, Heather? There is something written here, July 15th at 9:45. That's the date I will give you. Does she work now?
Judge, she is on federal social security,
Okay.
SSI and SSI.
Good enough. You just have to fill out a petition for court
And we
appointment.
put that in the file as well. There
You
should.
guys are way ahead of me. Good job.
Thank
Way to go. All right.
Had plenty of time to rest and come back and.
Well, it's good to have you here.
Thank you.
Are you coming back for good?
I'd like to.
Why don't you?
I need to get my parents completely settled in and.
Well, I'd love to have you, Mr. Baldwin.
All right, I will reconsider that. Yeah.
I'm appointing you a lawyer. You can go down the hall, pay your $200 bond, and get your notice for your new court.
She will be here, and she is not driving.
Good. Have a good day. Good luck. Do I have Grant Avery Galaska here? This is 25W838970.
Judge, for Grant Galatska, is that who you just called?
Yes.
I do have a victim on Zoom for that.
Okay, bring him or her in. Your name, sir?
Okay.
Okay, let's see, you were sentenced in my absence by Judge Kirsten. And he ordered no contact. And the allegation is that you failed to refrain from having contact, direct or indirect, with Brianna Sanchez. That's the charge. Now, that's a non-technical violation. And as a non-technical violation, even though you have no prior technical violations, I could, in fact, sentence you to 93 days under local ordinance. Actually, this was. You could get an extra 44 days, it looks like. Do you understand that?
Yes, Your Honor.
I see. You pled to attempted stalking. You pled to attempted stalking. So you could get an additional 44 days. Do you understand that?
Yes, Your Honor.
And did you sign an advice of rights form here today?
Yes, Your Honor.
Did you read it and understand it?
Yes, Your Honor.
If you plead guilty at any time, you'll be giving up all those rights, and we are not going to have a hearing. Do you understand that?
Yes, Your Honor.
All right, you have the right to an attorney. If you cannot afford one, I will appoint you one at public expense. Do you understand that?
Yes, sir.
Either way, you're entitled to one. You want a lawyer?
Yes, sir.
I'll enter a not guilty plea. Ma'am, can you unmute and tell me your name?
My name is Brianna Sanchez.
So I just arraigned Mr. Galaska for violating the no contact provision. He has the right to a lawyer, and I'm appointing him a lawyer, and I'm going to ask you to just stand by. Will you do that for me, please? I'd like to hear from you after he speaks to his lawyer, okay?
Sure, I can do that. Thank you.
Thank you very much. Sir, go out in the hall. We will set you up with an attorney, okay?
Thank you, sir.
Good luck. Come on up here, sir. And I want you to bring in that young lady that was here, Brianna Sanchez. Your appearance, your name,
Grand neighbor Gillespie, sir.
counsel.
James Schloff, 30720.
What's he gonna do?
He's going to acknowledge that he's in violation.
Call in, Jessica, if you would, John. If you plead guilty here, this is a non-technical violation, violating a no contact provision. So while you have no technicals, no prior technicals, if you plead guilty to violating the no contact provision, you could in fact receive the maximum in this case, which, because it was a plea to an attempt, appears to me to be 44 days or 42 days. I'm not sure which. Assume 44. Do you understand what I just said, sir?
Yes, Your Honor.
Did you sign, read, and understand an advice of rights form on this?
Yes, Your
If
Honor.
you plead guilty, you will be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Did you hear the judge's question?
Yeah. I was, is that what I'm doing, right?
He's acknowledging his violation.
Yes, I am acknowledging.
You understand if you plead guilty, we're not going to have a hearing, right?
Yes.
To the charge you violated the no contact provision by having contact, direct or indirect, with Brianna Sanchez, how do you plead?
Guilty, Your Honor.
Did you have contact with Brianna Sanchez?
Called Brianna. We never actually talked on the phone, but I did violate and call her phone.
How many times?
Just a few times.
How
but
many is just a few?
Probably 3 times or so.
And what did you say on those phone calls?
The one I was asking about her family because they were looking at social medias and driving by if they could just stop. And then the last one I sent was if we could just have a normal conversation, no threatening, no swearing, just have a normal conversation.
And what about the third one?
I don't even recall if I left a voicemail that time.
Sanchez, your name?
Brianna Sanchez.
You violated the no contact provision. You acknowledge that, correct?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
And accept your plea to violating the no contact provision. Ms. Sanchez and Ms. O'Donnell, your name. Would you tell me, please, what the substance of these violations was? I heard his version. He says, 1, he called, talked about his family. 2, he wanted to talk about a normal conversation. 3, he doesn't even remember if he left a message. Is that all true?
It is true. The first message was on May 2nd. He was just begging me to have a conversation with him, pretty much. The second voicemail was on May 19th. That was the one that he was talking about my family viewing his social media. I don't have control over what my family does when I'm not around. We don't speak about him. So I did send him a text message after I got that voicemail. Basically just telling him that just what I just said and to leave me alone or else I will be contacting his probation officer. The third voicemail was on June 11th. He just called and told me basically that he knew I was in a new relationship and he just hopes that I'm doing well and he's sorry for everything and blah, blah, blah. So.
Why are you taking it upon yourself to violate the no contact provision?
I don't know, Your Honor.
Well, you better come up with a quick answer. Do you have any other information, Ms. O'Donnell?
No, this is exactly what Ms. Sanchez had sent to me, the three phone calls, and her dates are exactly correct as she provided through for me. It's from the same phone number that Grant has provided me, so I know it is his number. She did leave her a voicemail every time on all three of these phone calls he made her.
Anything else anybody wants to say?
Just state to the court that I don't know the nature of how this case came about, but as violations go, it's unfortunate. I told him that it's still a court order, he must follow it, but there was no other crimes associated with it, no threats or anything like that. And I told him that no matter what other people do, that's up to them. This court can't order them to do anything one way or the other. So I did try to educate him on this. He's a working man, Your Honor. He worked until 3 o'clock this morning, has to go back at 3 o'clock this afternoon. No criminal history besides this case that I'm aware of. And no new charges arose from this case, Your Honor. He does have one more class to take. Otherwise, I think he's in full compliance with this court's order.
You gotta move on, sir. Anything you'd like to say?
First of all, I must say sorry, Brianna. Sorry for causing any issues. Sorry to the court for not following your guys' orders, because even though I might feel some way, I still have laws and rules that I have to abide by. So I would just like to apologize to all parties involved, and we can just. Is there anything I can do to improve that? I will do that, but I don't want any more issue.
Anything?
So he is compliant otherwise on the probation. He's completed his 2 days on the court work program. Finding the costs are paid in full. He does still have the impulse control class to complete. He still has time to do that. He does have a criminal history. In 2016, he did have a retail fraud that was dismissed under 771, but he does have a past criminal history. Again, Grant hadn't caused me any problems until this recently. I don't know what he's thinking. I don't know why we're reaching out to her. We know there's a no contact order. We're not together anymore. I don't understand why all of a sudden in May we're reaching out to her.
Anything else, Ms. Sanchez?
I think that above all else, I think he needs to focus on his mental health. I don't necessarily know that jail or, any kind of jail time would be necessarily helpful. I think it's really a mental health thing. And I think the impulse class is something he needs to do, like ASAP.
And he hasn't done it yet?
He has not completed.
Why not?
Honestly, I lost the phone number when I was gonna have my next meeting on the 28th of June. I was at Jessica at a meeting for that phone number, but that is why I have not attended the class yet.
You better get on that. You're to complete the impulse control program. How long of a program is that again?
It's a 1-day class at 6 hours.
Can you sign up for that in the next week and get in the next month?
It depends on when their next schedule is. I don't know when their next class is offered. They usually offer one at least every 6 to 8 weeks, give or take.
I'm gonna say by September 1. I'll modify that if they're not gonna offer one before then. Serve 2 days court work and pay $70 for that. Additional cost is $75. Don't have any more contact with her, or I'm gonna have to send you to jail. You understand that?
That's your offer.
Do you have the 145 now, or do you need time? I wish you well. Good luck. Set them up on the court work program, will you please, Jessica? And you pay that 145 now. Thank you very much.
Thank you, Your Honor.
People
Thank you, Your
again,
Honor.
thank you, man. Good luck. Thank you.
All right, last but not least, I'm going to call State of North Dakota versus Brian Lee Decker, 02-2026 CR 154. Present in court for the state, Attorney Tanya Duffy. Mr. Decker appears by reliable electronic means from the Barnes County Correctional Center. Mr. Decker, were you present in court when your rights were read to you earlier?
Yes, Your Honor.
Do you understand your rights?
Yes, sir.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. The law presumes that people who are appearing in court for their initial appearance in custody, the law presumes those people are indigent, and ordinarily a public defender is appointed automatically to cover today's hearing. Before going on the record, the court received notice from the assigned public defender that you intended to offer a guilty plea today and waive your right to counsel. Is that correct?
Absolutely, yes.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, sir.
You understand that you don't have to waive counsel. I could order Ms. Chisholm to get back online and represent you today. You understand?
Well, sir, I don't want to drag all this out. It's going to come up in no, I'm just going to plead guilty. I'm just going to get it done with and not save the court's time and mine.
Okay, and so Mr. Decker, I just want to make sure I'm really clear and the record is really clear. You have the right to have counsel and you're waiving that right, sir.
Yes, sir.
All right, the court will find a knowing and voluntary waiver of the right to counsel. And the court finds that the defendant is aware of his constitutional rights as they were read at the beginning of the court session. Mr. Decker, have you received a copy of the charging document?
Yes, sir.
Do you have that document in front of you?
Yes, sir.
Is your name spelled correctly in the upper left-hand corner of that document?
Yes, Your Honor. Yes.
All right. And you have the right to have me read that document to you in its entirety, or I can summarize the document for you. Which would you prefer?
We can summarize.
The state alleges on or about July 1, 2026 in Barnes County, North Dakota, that you committed 3 criminal offenses, 2 Class B misdemeanors and an infraction. In count 1, the state alleges that you committed the offense of driving under the influence, first offense within 7, in that you were driving or were in actual physical control of a motor vehicle under the influence of a drug or substance or combination of drugs or substances to a degree that renders you incapable of safely driving. As charged, that is a Class B misdemeanor. And we're going to talk about the penalties for counts 1 and 2 together because they're both Class B misdemeanors. In count 2, the state alleges on or about that same date in Barnes County, North Dakota, you committed the offense of driving under suspension. And Ms. Duffy, are you alleging that the suspension was alcohol related or child support related?
No, Your Honor.
Okay.
No, it's not.
So just stick with me. So that driving under suspension, the state alleges that you operated a motor vehicle at a time when your license was suspended or revoked for any in any jurisdiction for some reason that wasn't alcohol related or it wasn't child support related.
No, sir.
That offense is also a Class B misdemeanor. For both counts 1 and 2, the maximum penalty for those Class B misdemeanors, maximum penalty is 30 days in jail, a fine of up to $1,500 or both, court fees totaling $250. On count 1, the driving under in the influence, there is an applicable minimum mandatory penalty. The minimum mandatory penalty is a requirement that you obtain an addiction evaluation from a licensed addiction counselor. There is a minimum mandatory penalty of a $500 fine. And on counts 1 and 2, there is a minimum mandatory requirement that you submit fingerprints for inclusion in law enforcement's databases. Count 3, the state alleges on or about that same date, July 1, 2026, in Barnes County, North Dakota, that you committed the offense of unlawful possession of drug paraphernalia for use with marijuana or tetrahydrocannabinol. That is an infraction. An infraction is not punishable by jail. The maximum penalty for an infraction is a $1,000 fine, no applicable court fees, no applicable minimum mandatory penalties. For all 3 offenses, if your conduct caused any loss or financial harm to another person, the court can order restitution. For all 3 offenses, if you're not a United States citizen, a conviction can result in significant adverse immigration consequences. For all 3 offenses, if you're convicted of any one of them or all of them, there might be additional collateral consequences for which the court is not required to explain. An example of a collateral consequence, one among hundreds, if not thousands, of collateral consequences that might apply. In count one, if you're convicted of driving under the influence, and in count two, if you're convicted of driving under suspension, it likely will result in an additional consecutive license suspension or disqualification period. With respect to count one, understand that if you get another DUI within 7 years, or if you get another 3 DUIs within 15 years, the offense gradation increases and the maximum penalties increase and the minimum mandatory penalties increase. For count two, if you're able to restore your driving privileges within 60 days of the driving offense conduct date, so 60 days of July 1, you can move the court to dismiss the charge if you're able to restore your driving privileges within 60 days. If you're not able to restore your privileges within 60 days and your case is still pending, but you are able to restore your privileges while your case is still pending, sometimes the prosecutor will move to amend the charge or dismiss the charge, even though I can't force the prosecutor to do that or require the prosecutor to do that. Sometimes they still move to amend or dismiss the charge, even though they don't have to. You understand the nature of the charges and penalties as I've read them?
Yes, sir. Yes, Your Honor.
Do you understand that you can move to dismiss count two if you're able to restore your privileges within 60 days?
Yes, I could do that today, really. Well,
I'm just making sure that you understand that if you enter a guilty plea, you won't have that option. If you enter a not guilty plea, you would have that option if you're able to restore within 60 days. Understood?
I understand that. Then there's the option of bond and not being bonded out, and I'd rather not have to. It's all about money. I can't afford the whole pile of it. So I'd rather just and work with it.
Just to be clear, you understand the charges and the penalties.
Yes, sir.
I am going to ask you for a plea of either guilty or not guilty to each of these 3 counts. If you enter a guilty plea, your case will be over today. If you enter a not guilty plea, we will set your bail and schedule further proceedings. Do you understand what happens if you plead not guilty?
Yes.
Do you understand what happens if you plead guilty?
Yes.
And Ms. Duffy, is there a plea agreement in this case?
No.
And so, just to make sure, Mr. Decker, that you understand, the state is going to give me a sentencing recommendation if you plead guilty, and you can give me a sentencing recommendation if you plead guilty, but I'm free to impose whatever sentence I think is appropriate or just, and it might be harsher than what you would expect. It might not be. It might be the minimum mandatory penalty. But I want you to understand that I don't have to follow what the prosecutor is recommending. It's just that a recommendation.
Yes, Your Honor.
Understood?
Yes, sir.
So in count 1, driving under the influence, do you plead guilty or not guilty?
Guilty.
Count 2, driving under suspension, do you plead guilty or not guilty?
Guilty.
Count 3, unlawful possession of marijuana paraphernalia. To that count, how do you plead?
Not guilty. What? If you want to drag it on court, I'll plead guilty. Guilty. I ain't saying in jail. On a bond.
I'm a bit confused. I want to make sure I understand.
I'm
Mr.
guilty
Decker.
of unlawful possession of dark paraphernalia, yes.
So, Mr. Decker, are you pleading guilty or not guilty?
Guilty.
So the court will enter those guilty pleas. Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to plead guilty?
Nope. No, sir.
You understand that by pleading guilty that you're waiving all the rights that the court explained to you before?
Yes, Your Honor.
Do you understand that you're waiving any and all defenses that you could have had, any and all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case if you enter non-conditional guilty pleas?
Yes.
And do you still want to plead guilty?
Guilty.
Are you doing so freely, knowingly, and voluntarily?
Yes.
Do you need any time to speak with a lawyer about your case?
No.
And my understanding is that there is no plea agreement in place, so if the court accepts your pleas, I will do so on an open plea basis. Do you understand that?
Yes.
All right. Ms. Duffy, a brief factual basis, please.
In this case, back on July 1st, 2026, Trooper Mishler was on patrol with the North Dakota Highway Patrol. He conducted a traffic stop of a vehicle on I-94 near mile marker 284 in Barnes County. Trooper Mishler had previously been provided information from a different trooper, Trooper Wanger, that he had witnessed the driver who had matched the description of an individual who had suspended driving privileges based on who the registered owner of that vehicle was. Trooper Mishler also observed the vehicle driving onto the yellow lane of the driver. As a result, he conducted a traffic stop. He made contact with the driver, who was the defendant. He identified the passenger as Timmy Linderman. Upon his approach, Trooper Mishler believed that the defendant was under the influence of controlled substances, specifically drugs. He conducted field sobriety testing on the defendant. All of those tests indicated impairment. The defendant, Trooper Mishler, believed he was under the influence of a controlled substance stimulant based on his testing and his experience. Subsequently, he was placed under arrest. In the meantime, the passenger was also placed under arrest for an outstanding Barnes County warrant. Search was conducted of the vehicle. Within that vehicle, they found some drug paraphernalia for use with marijuana. And at the time of this offense, the defendant's driving privileges were also suspended.
Mr. Decker, is that what happened?
Yes, sir. In short, I was escorting a friend or an acquaintance, a guy I had run into, says he's from the area, and he was wanted to see his mom, so he was bringing him out this way. I work at the data center in Fargo. I was bringing him out this way. I wasn't looking at enjoying time out. I paid $1,000 to get my license off suspension. I paid out my butt to get the thing registered and everything like that. So I'm like one payment away to get my insurance and license out. I had to get my permit. First, I had his insurance in the permit. Then so I was like staggering. So here I am today with that driver suspension thing. I got so much money tied up into that. Then I was like $110 insurance, $29 insurance and a permit, and bam, I'd be legal. But apparently I wasn't. And as far as using drugs, I've been sober for over a year. I take Vyvanse. I have a doctor's prescription. I'm working on my medical card. The same doctor. As far as the marijuana stuff, that's not mine. The possession of it, but it's on the docket. I'm pretty familiar with the court systems, and I don't have enough money to pay bond and all that stuff. I'm not really wanting to do all that. I'm working with the Ridge, a whole bunch of people in Fargo. As far as like the status I'm on today, I don't know much more I can tell you. As far as actual using any drugs or DUI, no, but I am on a prescription Vyvanse, which may have, so, and then I took a urine test. He breathalyzed me. Of course, I blew zeros. I don't know what more you want from me. I'm not really enjoying the court system anymore in my life. I've been sober a year and I'm trying to get away from it all appropriately. So my fastest way, I'm thinking out of jail, is to plead guilty and leave it to your honor's hands, because I don't believe, and by knowledge, I am on medicine. I have it in my backpack. I have the prescription. I have my weed card. I have everything but my legal license to be pulled over, and that's a $29 insurance payment, which I was going to do yesterday, but I couldn't get a insurance company because I had a permit and then take the test. I got $1,000 to get free of my suspension. I got all this money. I just can't keep on doing it. And now I work at the data center. I'm probably going to do that job if you keep me in jail. That's $110,000 a year. So I'm not messing up. I'm not doing nothing wrong. I really am not.
Mr. Decker, I want to make sure. Stop talking now. What I heard from you is I was driving fine. My license is almost restored.
Yes,
the weed stuff isn't mine, and I have a valid prescription for it. The drug that I was under the influence of is a prescription drug.
Yes, sir.
And that I was taking it as prescribed. So what you're talking about sounds like a whole lot of defenses.
Yes.
And you also mentioned that you're pleading guilty just to get out of jail, not because you are in fact guilty. Those are generally things that are problems for me, because I don't accept guilty pleas from people who aren't guilty of the offenses.
Thank you, Your Honor, for listening. I don't feel guilty. I don't.
You need to stop talking. Just close it.
I'm sorry.
So Your speech is also very, very pressured and fast. And it causes me some concerns that you might still be under the influence of some form of stimulant. I know you were arrested yesterday. I have some concerns about this plea because you're not telling me that you're in fact guilty. You're telling me a whole bunch of things that constitute defenses. Are you telling me otherwise now, or are you telling me not to accept your guilty pleas?
I'm not guilty. I'm not guilty, but I'm pleading guilty. You're the judge, you decide. Either way, I'm gonna go to jail. I can't afford to fight your whole shit. And either way, I'm in jail.
You need to make sure you're not swearing in my courtroom.
Sorry.
You might not be physically present in my courtroom, but you're talking right now and you're swearing again. Stop.
I can't afford to fight your court system. I'm not giving time. I'd rather be guilty and get it over with. As far as your opinion of me being on drugs, cancel that because I am not.
Yeah, so
you're reading the screen and you're profiling up.
All right, you need to stop talking.
I'm not guilty, but I plead guilty. I'll end it there. Or you give me 30 days anyway.
I asked the court to set bond, withdraw his guilty pleas, and set it for further hearings.
I'm guilty. I'm not having that.
Sir, stop talking.
I'm guilty and I want to be charged guilty. I'm not very
Stop talking.
I am guilty.
I'm going to withdraw the defendant's guilty plea. I'm going to set bond. Sir, if you talk again, I'm going to mute the jail. You're talking out of turn. If that doesn't work, sir, I don't know what else to tell you. You need to hold off right now, okay? So I'm telling you to stop talking. You need to follow the court's order. Do you understand?
Yes, sir. I'm losing $110,000 an hour job, a year job right now. So what I'm going to do if you keep me in jail. $110,000.
Don't talk out of turn again. I'm asking you, do you understand my warning?
Yes, sir.
Now follow the court's order, which was to stop talking.
Thank you.
I am withdrawing the defendant's guilty plea. I have not accepted them. I have not found that they were freely, knowingly, and voluntarily entered, nor have I found an adequate factual basis. So under Rule 11D, the defendant has the absolute right to withdraw a guilty plea. I'm not accepting the defendant's guilty plea. Was a request by the state, and frankly, that was what the court was going to order anyway, so I'm granting that request. Pleas are withdrawn, not guilty pleas are entered on behalf of the defendant. I'm going to hear first from the state on bail, and then, Mr. Decker, I will give you an opportunity to be heard on bail, but you need to remain silent until I hear from the state. Ms. Duffy.
In this case, Your Honor, the defendant, his criminal history begins in 1991 with several NSF and no account cases, disorderly conduct 92, possession of marijuana. There's quite a few driving under suspensions along the way. Burglary 97, forgery 1997, criminal trespass 1998, felony bail jumping 1998, violation of protection order 2001, drug paraphernalia 2001, felony protection order violations times 10 in 2001, attempted violation of protection order 2001, two separate cases of forgery in 2002, felony theft in 2007, forgery 2007, some more NSFs in 2010, simple assault 2010, marijuana 2010, drugs in a motor vehicle in 2010, ingestion 2010, forgery times 4 2010, DUI in 2012, harassment in 2018. He's got more driving under suspensions in 2018 and 19. Fleeing in 2018, another NSF in 2019, theft times 2 and forgery again times 2 in 2020. Another forgery, separate cases in 2020, petty theft 2020, violation of disorderly conduct restraining order and orders prohibiting contact in 2020. Two separate cases of the disorderly conduct restraining order violations, disobedience of judicial order in 2020. Another incidents of the violation, disorderly conduct restraining order and disobedience in 2021. Unauthorized use times 2 and theft of a credit card in 2021. Possession of meth in 2021. Felony meth and drug paraphernalia in 2021. Possession of marijuana 2022. Disobedience 2022. Possession of meth and criminal trespass in 2023. Resisting law enforcement in 2023. Felony drug paraphernalia in 2025. some infraction marijuana ×2 in 2025, felony meth and felony drug paraphernalia from 2025. He should be on parole right now for that. He received a 2-year sentence that was imposed in July of last year, so he should be on parole. Presumably because it's not been 2 years since last July. So he should be on parole status for that last case. I didn't check about probationary or parole statuses for the cases before that. The defendant has a Drake, North Dakota address, so I don't know that he has any ties to Barnes County. I don't think any of his cases really came out of Barnes County. There's some in neighboring counties, but not Barnes that I recall seeing. I'd ask the court to set bond at $2,500 cash or in the alternative of $5,000 surety. A requirement that he maintain contact with his parole officer, no leaving the state, no driving without a valid license and insurance. Remain law abiding, no drugs or alcohol without a prescription, and any other conditions that the court deems to be appropriate.
What's the file he should be on parole for?
It should be 09-2025 CR 2379.
2379.
Correct.
All right. Mr. Decker, you have the absolute right to remain silent. If you choose to remain silent, your silence will not be used against you. You have the right to give me a statement on bail if you wish. But again, anything you say can and will be used against you. These are recorded proceedings. The prosecutor can get a copy of the transcript and use any statements of fact that you make against you in these proceedings or in other proceedings. Do you understand the court's warning?
Yes, Your Honor.
Is there anything that you want to tell me about bail before I set it?
Yes, if I may. There are several factors including bail. One, I have a vehicle that's sitting on the road, and if I can't make the bail, that's going to cost me money. Two, I don't have enough funds for bail. I'm from the Fargo area. I'm doing very well. I'm on parole. I work with the Ridge, recovery reentry center, all kinds of good stuff going on in my life. As far as ever not appearing for court, that doesn't seem to be ever an issue. And if it was ever on print, it's probably because I was in a jail, missed another court in another jail. And so that's never been an issue where I ran from a court hearing or afraid to go to a court hearing. That's not an issue. I'm doing so well in life right now, and the finances put into it are enormous. And to have this collapse under me is tough to do. And that if I can't afford the bail to get my vehicle to go back to work, I mean that's I can't. I mean I got everything I got going on financially out there. I mean, but I ain't in trouble as far as like a massive society or, I'm doing really well. I'm really managed really well. Really, those guys are awesome. And as far as like, I don't know what more I can tell you. Am I gonna not miss court? Obviously, I'm not gonna miss court. Can I afford a bail? No, I cannot. I have a vehicle on the road that's cost money. I got a job that's gonna cost me money. All this, but I don't have the money to do $500. Up here, I'm good. The Ridge will get me there. Those guys are getting me. So, I know it's time. As far as my budget worth money to secure coming to court versus my word, I apologize. The money's worth more than my word. But my word is obviously being bring to court. I haven't missed a word a court here ever. I don't run. I don't need to. And I'm more worried about losing the pile of stuff I have going on that's positive in my life. And I'm going to end the shot anyway. That's why I was hoping just to get done and go and not lose everything. Versus dragging around a $500 bond. $500 is going to cost me a lifetime of money. It's going to cost me a life. Not literally, but what I built up, what I got going on today. With all the charges back behind me and where I'm at today and the beautiful how I am, that $500 is going to collapse my whole world. If I just can't go and come back on a later date to court. It's going to cost me everything, a lot.
All right.
Come see his mom. He didn't even go stop and see her. I mean, come on. That's painful.
Mr. Decker, I'm going to set bail here in just a moment. I'm going to tell you right now, your next court date is October 6, 2026 at 1 p.m. Central Time in the Barnes County Courthouse in Valley City, North Dakota. That date, one more time, October 6, 2026 at 1 p.m. Central Time. To understand when you next need to be in court.
Sure.
I am going to remind you, and I've already made a finding that you waive the right to counsel, but I'm going to remind you, sir, that if you want counsel, it sounds like you probably would financially qualify for a public defender to help you. You can always decide to hire a lawyer, and you can always decide to apply for a public defender at a later time, but it's in your best interest so your lawyer can help you and make decisions with you and give you advice if you apply for a public defender sooner rather than later. Do you understand? You can always change your mind about the right to a public defender as long as your case is still pending.
Yes, thank you.
All right. The court's considered the constitutional provisions concerning bail, including Article 1, Section 11 of the North Dakota State Constitution. The court's considered Rule 46, in particular Rule 46A, that has a presumption of release on one's recognizance or unsecured appearance bond unless the court has sufficient evidence before it to rebut the presumption of release on unsecured appearance bond to ensure the defendant appears. The state indicated Mr. Decker has some previous bail jumping and non-appearances. That posed the court some concern. Mr. Decker asserts that he has always made it to court. Court finds that the state's recitation of a bail jumping conviction is sufficient to rebut the presumption. The court's weighed the factors set forth in Rule 46A3 on release. The court finds the following bail to be appropriate and reasonable under the facts and circumstances of the case, including the nature and circumstances of the offense, the defendant's criminal history, the ties to the community, and the other factors the court is required to consider. The court has considered the declaration of probable cause. This was a search warrant case. I granted the search warrant based on the statements made by the trooper at the time. And so I know there's going to be a chemical test returned at some point. Courts again weighed those factors. The fact that the defendant has a rather lengthy criminal history, that he's currently on parole in file 09-2025 CR 2379, that he has a parole officer in that file, the fact that this is charged as a B misdemeanor level case, it's a driving offense or what could arguably be construed as a victimless crime. I don't think that it is victimless. Society is the victim in this type of offense. The courts weighed the dangerousness to the community, risk of non-appearance, flight. And again, all those factors that are set forth in Rule 46A3. Court finds the following bail is sufficient but not greater than necessary to secure the defendant's appearance. And the court further finds that the non-monetary conditions that are imposed are tied to the Rule 46 release factors and appropriate to ensure the defendant appears when required. Bail will be set for the time being at $1,000 cash or an alternative $3,000 corporate charity. In addition, in addition to those monetary bail conditions, which are imposed in the alternative at the defendant's option, the following additional conditions also will apply. The defendant shall remain law-abiding, not leave North Dakota without the advanced express permission of the court, notify the court of any change of address, employment, phone number, or email within 24 hours of any such change, not possess or use alcohol or controlled substances unless prescribed.
I'll take my son. I'm done.
Sit down.
You ruined my life, man. I don't need to live.
Mr. Decker,
The fucking life.
it's walked away from the court. Sit down or I will hold you in contempt.
Well, there's not $1,000. You ruined my fucking life.
Stop talking while
I
I'm
don't give a
finishing
fuck
up
what
my...
you're saying, sir. You can fuck off.
Sir,
Fuck
I'm
off.
holding you in contempt for conduct that occurred in the
Fuck
court's
off.
presence.
$1,000. You ruined my life. You can fuck off.
Sir,
Fuck off.
I have repeatedly warned you. You
I
are
said,
not...
fuck off. $1,000. You ruined my life.
Summary
You can
contempt.
fuck off, Judge.
I'm
$1,000.
imposing a $500 fine as a summary contempt. Sit down. Mr. Decker is flipping me off. The jail has muted the microphone. He has walked away from the court several times. Conditions are as follows: remain law-abiding, not leave North Dakota without the advance express permission of the court. Notify the court of any change of address, employment, phone number, or email within 24 hours of any such change. Not possess or use alcohol or controlled substances unless prescribed. Sign a promise to appear in waiver of extradition before release. Comply with all currently imposed parole and or probation conditions in file 09-2025 CR 2379, which are incorporated by reference into the court's bond order. Meet with Mr. Decker's parole and probation officer within 72 hours of release. Have minimum weekly contact with the parole and probation office. Personally appear for all scheduled court hearings. Your next court date, sir, October 6, 2026 at 1 p.m. Central Time, Barnes County Courthouse in Valley City, North Dakota. Submit fingerprints before release. Not drive or operate a motor vehicle without a valid license or permit to do so, and valid liability insurance as required by North Dakota law. Again, the court has imposed a $500 fine for the defendant's willful and intentional contempt of court, for swearing and cursing at the court after being given warnings to do so, getting up during the proceedings, interrupting the court's proceedings in the court's presence, and obstructing the court's process and abusing the dignity of the court. As such, the court imposed a $500 contempt finding. And I'm doing so under the court's authority under the statute, which I will read in just a moment. Under North Dakota Century Code, Chapter 2710, 01.2, the court may impose a remedial or punitive sanction for contempt of court under this chapter. Contempt as defined by Century Code Section 2710.01.1, Sub 1, Sub A includes intentional misconduct in the presence of the court which interferes with the court proceeding or with the administration of justice, or which impairs the respect due the court. A punitive sanction includes a sanction of imprisonment if the sentence is for a definite period of time. A sanction requiring a payment of a sum of money is punitive if the sanction is not conditioned upon performance or non-performance of an act, and the sanction's purpose is to uphold the authority of the court. Here, the court finds Mr. Decker's behavior constitutes intentional misconduct in the presence of the court. The court finds that Mr. Decker's conduct interfered with the court proceeding or with the administration of justice and impairs due respect to the court. The court imposed a $500 sanction, which the court intends to be punitive in nature. And again, it is not conditioned upon the performance or non-performance of an act. The court finds beyond a reasonable doubt that that offense or that conduct occurred. And again, the sanction's purpose is to uphold the authority and dignity of the court. An order of contempt will issue in writing. Ms. Duffy, do you have any questions about the court's order?
No, Your Honor.
Do you have any questions about any other portion of today's proceedings?
No, Your Honor.
I'll have the jail unmute Mr. Decker.
I have a right to remain silent. I choose to do so.
Stop talking until I ask you a question.
I understand the clerk saying I have a right to remain silent. I have nothing to
Mr.
say.
Decker, do you understand the court's bail order?
I say nothing to you.
Mr. Decker, I asked you a question. Do you understand the court's bail order?
Yeah, I said fuck off. I say nothing to you.
Mr. Decker, if you continue to swear in court, I will hold you in contempt again.
Oh, no.
I'd prefer that you don't do that.
Okay, go ask some questions. I said fuck off. I ain't saying nothing.
Sir, you are
Yeah.
a breath.
If you even know that for $1,000, fuck off, Judge. I got no respect for you.
Again, sir,
Fuck off, I said.
I'm holding you in contempt again.
Again,
Imposing $50.
Fuck
It is punitive and
powerful. Fuck off.
all right, we're done.
$1,000, you punk bitch. Fuck off.
A written
You stuff like that, you piece of shit.
done. Have a nice day. We're off the record.
Well, that happened. Yeah, that guy was not happy. You kind of tell. I got these feelings as he spoke that he had a severe disdain for the jurisprudence of the court and their authority over him. Ladies and gentlemen, I want to thank you very much for hanging out with me tonight. Man, I told you it was not going to end well. I did warn you. It was right there in the thumbnail. And it did not end well. We're ending early because Hutch has got a long one tonight. This is part 3 of an interesting case that I've been watching. I'm really interested to see what's going to happen. So I'm going to say thank you very much for catching chaos. Coming by. Let's do this indeed. We're going to be doing it again tomorrow. There's not any court tomorrow, but I've saved some stuff back. As a matter of fact, I've got a really long Judge Middleton that we're probably going to be watching together. It's going to be one case. Might not be 2 hours. Might just be like an hour and a half. We'll see. I'm not sure exactly how long it is. I know it's a long case. It's an interesting case. You'll enjoy it. Whitney Greek, thank you so much for your super chat. And Darth Steven, you object. I object. All objections, Steven. All objections. Thank you for hanging out. I told you to not miss the fireworks. Sovereign Legal Encounters dropped by. We're coming to see you very soon, my good friend. Thank you for coming by. Specs, Alex the Dane Mom, Spider Art, Shiloh. I'm sorry, I can say your name. Shiloh Spider Art. Specs 100 times over. Thank you all for all the jewels and the cool little pop-up things. I don't even know what to call those. Those are really interesting, aren't they? Yeah. You know, when I come to this screen, it's because I want to say a special thank you to all these people whose names are now scrolling across the screen. This thing we call credits. And I figured out how to make credits happen a while back, and I like doing the credits. It's cool. Look at all these people. That bot's nut. All these people are great people. All these names are amazing people. And I'm sure there's some lurkers out there whose names might not even be on this list. Thank you all for hanging out here. Do stay tuned for Hutch. He's got like I said, part 3 of big case has been going on for days. He's cut it into multiple parts for us. It's a good one. Hang out, go over there, chat. Thank you all for being here. As always, I am your lone wolf Uso. I'm the strange little guy who hides behind Wolf and puts together these weird little compilations of court cases that happen every single day. As cautionary tales we can all learn from. For now, till I see you tomorrow, I'm your lone wolf Uso. I am out. Can't you feel it's all over? Come on, you can feel it's all over, people. Can't you feel it's all over? Everybody, it's all over, people. Let's go.